Madam Clerk, please open court.
The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. Welcome to your Supreme Court of North Carolina. The court calls 315PA18-2 Cooper versus Berger et al. Mr. Phillips.
Thank you, Your Honor. May it please the court, my name is Jim Phillips with the law firm of Brooks, Pierce, McClendon, Humphrey, and Leonard. Here virtually with me are my partners, Eric David and Dan Smith, and we appear on behalf of Governor Roy Cooper. I would like to acknowledge and express appreciation for the fine amicus brief filed by the Attorney General on behalf of the state of North Carolina. And I would like to reserve 5 minutes for rebuttal. We believe this case is straightforward. Congress has appropriated 3 block grants, one for community development, one for maternal health, one for substance abuse. And Congress has legislated how that money is to be used and what uses are prohibited. Congress has directed the executive branch agencies in North Carolina to distribute that money to third parties to accomplish those purposes. And it holds those executive branch agencies accountable to do that. Congress didn't say, as it does with some federal block grants, that the North Carolina General Assembly can be involved in this process. So the appropriation has occurred. The legislating has been done by Congress and is finished. All that's left to do is faithful execution of the federal law governing the use of those funds. Our Constitution is clear that faithful execution is the job of the governor and the executive branch. There is no room for the General Assembly's involvement, and their actions in appropriating these 3 federal block grants violates the separation of powers. I'd like to focus on 3 aspects of what I just talked about. First, the appropriation of those funds. These federal block grants have already been appropriated by law, in this instance by Congress. And that's what satisfies Article 5, Section 7, our Constitution's appropriations clause. Even if they had not been, even if that were not true, those funds are custodial funds that have come to the executive branch of our state government, impressed with an obligation to be used for a particular purpose and restricted against certain uses. Finally, if either of those 2 things are true, if they've been appropriated consistent with our Constitution, or if they are custodial funds, then the General Assembly's involvement violates separation of powers. Let's talk first about appropriation. Article 5, Section 7 of the Constitution says that no money shall be drawn from the state treasury except in consequence of appropriation made by law. The 3 federal block grants at issue here have been appropriated by law, by the U.S. Congress, and nothing more under our Constitution is required for the executive branch to draw and expend these funds. Under our Constitution, an appropriation made by law is not limited to an enactment by the General Assembly. Article 9, Section 6 of our Constitution acknowledges that appropriations may be made by the United States, by the state of North Carolina, or by the terms of a grant. All of these are appropriations made by law. In Article 5, if Article 5, Section 7 required an appropriation by the General Assembly, it would say so. Article 9, Section 6 references appropriations made by the states specifically. So So our framers knew how to say that. And throughout Article 5, the General Assembly is referenced by name repeatedly and authorized to enact laws. But Article 5, Section 7 doesn't limit appropriations to those made by the General Assembly. It's broader.
Mr. Phillips, Mr. Phillips, I'm sorry to interrupt you, but I have a question.
Justice Hudson.
Article 5, Section 7 specifically says that no money shall be drawn from the state treasury, but in consequence of appropriation. When you were discussing appropriation by Congress, that's not drawing money from the state treasury, is it? Isn't it appropriating federal money to go to the state treasury?
That is drawing federal money from the federal treasury to go to the state of North Carolina. But Article 5, Section 7, Justice Hudson, specifically says that money may be drawn from the state treasury if an appropriation is made by law, not by the General Assembly, and an appropriation has been made. We believe...
Is it your position that the money from the federal government did not go into the state treasury?
Your Honor, that was the next thing out of my mouth. That is our position, that the money is not in the state treasury. But even if it were, an appropriation of that money has been made by law. As Article 9, Section 6 says, there are a variety of appropriations by law.
One more quick follow-up. So are you saying that the money was appropriated to be drawn from the state treasury before it was ever in the state treasury?
Your Honor, our position is that the money never, with regard to these 3 block grants, because of the restrictions on them, is not in the state treasury. But even if it is, we still win. Even if it is been an appropriation made by law. So whether the money is within or without, we believe that faithful execution is the next step in the process.
Let me jump in with something of a follow-up question to the ones that Justice Hudson asked. Are you contending that the federal statutes mandate that the decision as to the entities to whom the funds ultimately should be dispersed has to be made by the executive branch?
Your Honor, we're not arguing a supremacy clause, that the supremacy clause controls here.
So well, what do you mean when you say that?
By that, I mean, we don't contend that the federal statutes dictate that. We think state law controls, but we believe that the federal law is instructive. When Congress intended for the General Assembly to have an involvement here, as it did with the workforce grant and the child care grant, those federal law grants specifically state that the legislative branch may be involved. Here, that is not so. And the case law is, of course, legion, that when Congress repeatedly says something, as it does with other federal block grants, but doesn't here, that's instructive of their intent.
But are you arguing that the statutes as written mandate that there be no legislative involvement, that the identification of the actual recipients be made by the General Assembly? I thought you said no, and then something in your last answer seemed to be to come back from that a little bit. I may have been misunderstanding.
So, Your Honor, we've cited case on our brief that says that the federal government can, of course, tie conditions to funding that it makes. And so I think it's the opposite of what you're asking. In those statutes where the legislature, where Congress has said the General Assembly can be involved, we've not sued over those, because closer question as to whether General Assembly involvement is appropriate. Congress has said it could be. Here, Congress has said no, has not said that.
It hadn't said, at least as I read the statutes, it hasn't said anything one way or the other. It just says that the money goes to the state And,
Your Honor, I think that's right. And
and
so
with one and two of, at least two of the three programs, I can't find anything in the statute that defines the state.
Your Honor, I think that's right.
Okay.
The state is
There's enough statutes here. I'm never sure whether I'm right or wrong when I start fishing through the federal code.
Amen to that. Community Development Block Grant does define the state as any instrumentality designated by the governor.
It says, but it said, at least I thought that one said the state or any instrumentality designated by the governor.
The other two are silent as to that.
Okay. All right.
And
So just to make sure I'm finishing up here, you're saying in effect that the fact that other statutes reference the legislature and these don't suggest, you don't seem to be going so far as to say that that dichotomy mandates a certain outcome. You just seem to me to be saying that it's relevant to an examination of what the state ought to do under state law.
That's right, Your Honor. And then state law kicks in. And then law kicks in, and it's an appropriation made by law. These are custodial funds, and faithful execution is the only thing left to occur. That's exactly right.
Thank you.
So, Your Honor, returning to the question of who is the state or who is in charge of these funds, that takes us to the issue of custodial funds. Even if these funds had not been appropriated, they would be beyond the General Assembly's appropriation power because they are custodial funds, not derived from state tax revenue or other state revenue, and given to the state to be used for a particular purpose. Executive branch agencies are the custodians of these funds, responsible for carrying out what Congress directed. And to be clear, and this really goes to the question, Justice Ervin, that you asked about who is the state. The nexus between these executive branch agencies and the three federal block grants is significant. The governor and these executive branch agencies submit the applications for the federal block grants. They create the plan for the use of those funds, which the federal government approves. They draw down the funds only at the time they're to be used and distributed. They report to the federal government on the use of the funds. And I think most importantly, they are the agencies that the federal government looks to for oversight of the funds and holds accountable for their use consistent with the plan. Both our Constitution and the State Budget Act recognize the existence of custodial funds that are outside the state treasury and beyond the General Assembly's appropriation power. Article 9, Section 6, again, of our Constitution directs that grants made to the state and not otherwise appropriated by the terms of the grant shall be paid into the state treasury and used for education. This language acknowledges that a grant to the state may already be appropriated for a particular purpose by the terms of the grant. That describes the three federal block grants at issue here. They are, by the terms attached by Congress to the grants, appropriated for a particular purpose. They are akin to funds held in trust. And in fact, the State Budget Act exempts custodial funds from the definition of state funds.
So, Mr. Phillips, let me ask you a question. Is your argument that any federal block grants that do not expressly say that they should be appropriated by the legislature, that the default is they should always be appropriated by the governor?
No, Your Honor. We're focused on these three federal block grants.
So what's unique about these three?
I think, Your Honor, first of all, the federal statutes do say, as you noted, or do not say that Congress can be involved. Second, other courts around the country who have looked at this issue have looked at the purposes of the grants, the manner in which they're to be expended. And our Supreme Court in 1982 specifically You know, the governor and the leadership of the General Assembly came to this court in 1982 and asked for an advisory opinion in NRA separation of powers as to whether the governor or the legislature controlled the decision with regard to use of federal block grants. This court said then that it couldn't answer that question, that it must look to the purpose of the grant, for whom they were intended, and the conditions placed on the grant. That's where we have focused our energy in looking at these three federal block grants. The purpose, for whom they were intended, and most particularly, I think, the conditions placed on them.
But wouldn't your argument extend to any block grants that do not expressly say to be appropriated by the legislature?
Your Honor, that's not the position we're taking today. We're focused on these three federal block grants. And as this court has said, because ultimately this is a separation of powers question, that separation of powers cases are best dealt with on a case-by-case basis rather than with bright line rules. And so
let me to follow up on
suggesting this.
Mr. Phillips, to follow up on Justice Davis's question. I certainly haven't sat down and read all the statutory provisions of all federal block grant programs. I'd probably be reading till sometime next year. But it seems to me, generally speaking, most block grant programs have a specific purpose that are intended. They specify what the money can and can't be used for. Given that assumption, what specific inquiry needs to be made, in your view, to determine when is or isn't subject to legislative appropriation beyond presence or absence of language referring to legislative appropriation?
So, Your Honor, I think the focus is on the primary focus. This court, as I said the purpose of the grants, for whom they were intended, and the conditions placed on them. I think the critical question is the conditions placed on them. And because that, I believe, determines whether these funds are custodial funds or whether they are like revenue sharing was back in the 70s and 80s, just a gift to the state to supplement its budget. With regard to funds of that nature that are just given to the state for any use, we don't argue that the General Assembly doesn't have a role with regard to that.
Well, how would you distinguish between a set of conditions that did or did not authorize legislative appropriation once you get past the revenue sharing example?
Your Honor, I think here, I think in this case, if you look at a statute, as the three statutes at issue here are, where a specific list of authorized uses is set forth, and where a specific list of specific prohibitions is set forth, that's a good way to analyze it. And here, in all three of these statutes,
I'm sorry to interrupt you, Mr. Phillips, but you're saying in essence, you think the key factor is whether there are a list of conditions that say what the money can and cannot be used for?
Your Honor, that's the case here. And
so are you arguing then that in the event that the statutory provisions in question contain such a double-sided list that suggests that these fund in question is custodial and therefore not subject to legislative appropriation?
So I think secondly, I think that is part of it, Your Honor. I think another part of it is what the statute says about who is looked to for accountability. And here, the executive agencies are clearly the entities that are accountable to the federal government for the use of the funds. I think those things in combination, restrictions and who is responsible for assuring that the purposes and restrictions are met. You know, the federal government wants somebody they can pick up and call. And in the record is a letter with regard to the community block grant, community development block grant. You know, they're not picking up the phone and calling the General Assembly because the General Assembly is not executing the law. And the restrictions and the requirements and the accountability all rest with the executive branch agencies. And we believe that that is determinative. Your Honor, the final step in the analysis is that because these federal block grant monies have already been appropriated by law, or because they're custodial funds, and because they have been directed by Congress to a North Carolina executive branch agency to administer, then all that is left for the governor and those executive agencies to do is to faithfully execute the terms of federal law attached to the grant. That includes choosing how to accomplish the policy goals set by Congress. That discretion is what this court called in Cooper v. Berger the interstitial policy choices delegated to the executive branch by legislation. In this instance, by federal legislation enacted by Congress. That it is the governor and the executive branch that have the responsibility and the authority to choose how to execute federal law is underscored by the fact that it's North Carolina's executive branch that the federal government holds accountable for these funds. The executive branch not only plans for the use of the funds, applies for the funds, receives and distributes the funds, it's responsible for their oversight and accountability. The General Assembly may choose not to appropriate required matching funds or not to meet federally required maintenance of effort, but having chosen to do those things, as it has with these 3 block grants, its job is over. To appropriate these funds as it has done here is an attempt by the General Assembly to assign to itself the task of executing the law. That is not its job under our Constitution, and it violates the separation of powers clause.
Mr. Phillips, may I ask you a question about the implications of the rule as the Court of Appeals has laid out? Are there other grant funds that the state receives through the Treasury, medical research funds that UNC receives? Are there other, how broad is the scope of the Court of Appeals opinion?
Your Honor, that's the final thing I wanted to cover, so thank you very much for that question. The Court of Appeals opinion allows the General Assembly to statutorily define the state treasury, a constitutional term, and it is simply wrong. The task of interpreting our Constitution is assigned to the judicial branch and ultimately to this court. Yet the Court of Appeals opinion abrogates that responsibility and says that if a statute directs funds to be paid into an account held by the state treasurer, then those funds are in the state treasury, only because a statute says so. The parade of horribles that follows if this is the law is long and frightening. The General Assembly, on a whim, can change the meaning of our Constitution. The General Assembly, by statute, can redirect gifts and grants to our universities, museums, and other state institutions away from those institutions, and it can use it for its own purposes. Right now, statutes are on the books which say that that won't happen. But those statutes, if the state treasury has no meaning, can be repealed, and that can change.
So is your argument, Mr. Phillips, that the term state treasury has a fixed constitutional meaning that the legislature cannot modify?
Your Honor, I think that this court defines the term. The General Assembly, of course, can pass legislation which says this or that is in the state treasury, but ultimately it's for this court to decide whether that's right or not, because I do believe that it has boundaries. The Court of Appeals opinion abandons those boundaries and says that whatever the General Assembly says is in the state treasury is in the state treasury. So if in fact that's the law, as the Attorney General points out, settlements with third parties will be more difficult, if not impossible, to attain.
On the other hand, though, is the state treasury limited then to just fines and taxes and penalties? I know you talk about it being too expansive, but on the other hand, is it that restrictive?
Your Honor, that's what, in Gardner, you said that the state treasury was tax revenue and other funds obtained pursuant to the enforcement of state law. Now, maybe the treasury is broader than that, and this court can decide. But we would argue that it is not so broad as to cover the funds at issue here, which have been appropriated and which are custodial funds. Thank you for your time. I'll reserve my 5 minutes.
Mr. Wharf?
Your Honor, may it please the court, my name is Martin Wharf, and together with Noah Huffstetler, we represent the legislative defendants, President Pro Tem Berger, and Speaker Moore. The state of North Carolina, not the office of governor, is the recipient of federal block grants. These funds are receipts to the public purse. The question before this court, based on that fact, is whether legislative appropriation of federal block grants is prohibited by federal law or by our Constitution. The answer is no. To the contrary, first, nothing in the federal law regarding these block grants prohibits legislative appropriation. Second, our Constitution and this court's jurisprudence do not contemplate public funds that are outside of the state treasury. There's nothing in the Constitution that prohibits federal funds being in the treasury and appropriated by law. Third, our state constitution and laws divide the responsibility for enacting a budget of anticipated revenue and proposed expenditures of the state between the legislative and executive branches. This has been the status quo since the current Constitution was enacted. Looking first, Your Honors, at federal law, we know we're not looking for authorization, we're looking for prohibitions. When we review an act of the General Assembly, we determine whether there is a federal law or our Constitution that prohibits that act. What we see here in the federal law is the hallmark of block grants is discretionary spending, broad categories for which the state can use the money. And we have numerous examples cited in the record in the briefs that Congress has left the issue of state legislative appropriation of federal funds to the states for each state to decide. That's both in the Lamb case and cited by our Court of Appeals referencing the commission determined by Congress. And Justice Hudson, to turn to one of your questions about appropriation, the money that Congress appropriates, they appropriate to a federal agency. They do not appropriate that money to the office of the governor. They appropriate it to a federal agency. The state of North Carolina, like the other 50 states, then applies for that money, and the money is dispersed to the state pursuant to federal law. The federal agencies are following federal law in dispersing that money pursuant to those applications.
So let me interrupt you just for a second. So I take it that you disagree with Mr. Phillips' argument that the funds are appropriated by that process.
The funds are appropriated by Congress to the federal agency, and that's where congressional appropriation ends. It's the federal law.
But not within the purposes of this issue that we were talking about here. Absolutely
not. Congress is not the appropriation by law to move money from the state of North Carolina Treasury to someone else.
I understand your argument there. What's your strongest authority in support of that position?
Well, Your Honor, the money, the congressional appropriation, there's nothing in the federal law that would give money straight to North Carolina or any other state that you might see. The federal government typically, if they give money to states, they're going to do that through a federal agency. That happened even with the CARES Act funding most recently. They don't give it straight to the state. They give it to an agency to disperse according to federal law. And that law, as we look at, to Justice Irvin's point, at least these 3 block grants define the state to include, if not exclusively in some, the states of the Union and Commonwealth of Puerto Rico, and et cetera. You can see that in several of the federal statutes. And the question was asked about what was unique about these 3 block grants as opposed to others. The only unique thing that we can see is that these are the 3 block grants in this budget in 2017 that the General Assembly disagreed with the priorities of the governor. All block grant money passed through the state budget process, including these 3 block grants. And at the Court of Appeals, it was conceded that these were the 3 where there was some disagreement.
Can I just ask a factual question? Do you know if this is the first time the General Assembly has sought to appropriate funds differently from how the governor represented to the federal government they would be appropriated?
Well, no, Your Honor, this is not the first time. There have been numerous occasions with all 6 governors before Governor Cooper, since federal block grants have been given to states through the federal government in the early 80s. There have been disagreements and allocations of money differently. And it's not to say that the governor has bound the state of North Carolina at all by submitting a plan, the executive branch submitting a plan to the federal government in a grant. Those grants can be changed, and so long as the money is not being spent out of one of the numerous categories in a particular grant, then anything within those categories is fine.
So then you would agree that the legislature's discretion is constrained by what the federal grant program allows or doesn't allow?
In certain respects, yes. It's simply putting money into the budget process, any money, does not necessarily mean that the legislature can do what they want to with that money. If there's a maternal block grant and one of the categories is something to do with infant mortality, just because that money is appropriated by the state of North Carolina through the budget process does not mean that the General Assembly could say that money is going to be used for roads or transportation. Those strings that come with that money, those categories are still applicable because they are applicable to the state of North Carolina. Whether it's the governor or Congress, the General Assembly, the state of North Carolina is the recipient of those funds, and the state of North Carolina is the entity that is on the hook if something goes wrong with those.
To follow up on Justice, several questions that Justice Earls has asked, which were also questions that I was going to ask. First of all, what is your understanding of the definition of an appropriation for purposes of Article 5, Section 7, Parentheses 1?
Your Honor, appropriation, I think, is the allocation or setting aside of a sum of money for a specific purpose.
Let's talk about in terms of is anybody other than the General Assembly contemplated with the use of appropriation in the constitutional provision that's in question here?
No, simply appropriation.
Why not?
Appropriation is typically done by a legislative act. That's defined. You can see that plain language in Black's Law or the American Heritage Dictionary when you look at the word appropriation. So appropriation by law is a legislative act, and it cannot be an appropriation by an executive order or in another means that might be available simply to the governor. It has to be appropriated by law.
And your argument that we don't have an appropriation here by Congress is what?
that Congress actually appropriated its money, the federal money, to a federal agency. That's where it sits. For instance, that money, if North Carolina did not make an application for that money, we wouldn't receive it. So there has to be an application to the federal government for that money, and that application is in the name of the state of North Carolina. And you can see that in the record, both at rule in several of the applications, the grantee is the state of North Carolina. It is not the office of the governor. And even if it were, any state agency is an agent of the state. That's in its name. It does not exist separate and apart from the state of North Carolina. So when we look, I think, at the federal law, there's nothing in the federal law that would prohibit the General Assembly in North Carolina from appropriating funds through its constitutional budget process.
Why would there not be a right under that type of argument for the legislature to appropriate funds donated to the university system, for example?
Well, Your Honor, we have state laws that suggest that.
But I think we're talking constitutional provisions here. I mean, if the Constitution basically says that all expenditures out of the state of money that's physically in the state treasury have to be appropriations, and if appropriations are decisions made by the General Assembly, why is the concern that Justice Earle's question to Mr. Phillips a minute ago, why isn't that a valid one?
Well, the issue there, Your Honor, is that the Constitution speaks only of appropriation by law. So the constitutional requirement is simply that the money be appropriated by the General Assembly. The law that's at issue in any particular grant or gift is in part a review of both the enactment process by the General Assembly and signing it into law by the governor or enacting over a veto. A specific law may deal with a specific grant or gift or something like that, but it is still an appropriation by law. It is not an appropriation that occurs by executive order because the money is not in the state treasury, which is what Mr. Phillips is arguing. He's saying that the money is not in the state treasury in a constitutional sense, that there's some bucket of funds that exists outside of what a state treasury is. And this court in Gardner referred to the state treasury as a place where public funds are deposited, kept, and dispersed. And it looked at that by looking at how you define what a treasurer is. And so to me, I don't think that there is a pool of money that exists in our constitutional setting outside of the state treasury. And if the money is in the state treasury, it is appropriated by law. And that law includes both in many cases, it includes the recommended budget of the governor and the enactment by the General Assembly with the governor's signing into law. Go ahead, Your Honor.
Well, let's say hypothetically that a person who has more money than I do decides to donate sufficient money to set up a specific professorship at UNCG and gives the money to UNCG. Can UNCG spend that money without the legislature appropriating those funds?
Without appropriation, I don't think so. No. But can the appropriation process change what the benefactor has said? No, it cannot. Because you can.
So then you're suggesting that the legislature, I mean, I don't know why a legislature would do it, but hypothetically, let's say a legislature didn't want to set up the professorship.
Right.
Could they just say, no, we're not going to appropriate it, and therefore nothing ever happens with the donation?
To your point, I guess that is conceivable that it could happen that way, but that's not because any other issue that I don't think in reality it would happen that way, because in fact we do have laws that state. You can look at 14776.1, which is in page 5 of the handout, and there you can see that the terms of an instrument evidencing a cash gift or donation are binding obligation of the state. Nothing in this section shall be construed to supersede, authorize a deviation from the terms of an instrument evidencing a gift or donation acting, setting forth the purpose for which the funds may be used. But that does not mean that it's not in the state treasury and still appropriated by law. There is the law that appropriates that money according to the gift of the grant, if the grant is specific enough to do so. When you look at these federal block grants, Your Honor, these by federal statute are given to the state of North Carolina. They're not given to an agency outside of some relationship with the state as a whole. An analogy that I like to think about it is both a funneling technique, that you start off with the money in the federal government. The grant can be given to North Carolina. There's some guardrails attached to that by the federal government, by federal law, but there's still a wide discretion that can be used. For example, if you, as opposed to getting money for your birthday, if you get a Target gift card for your birthday, you can spend that money at Target. You cannot spend it at Best Buy or somewhere else, but you can buy anything you want in Target. And that's kind of what the federal government is saying with a block grant. Here is the area of interest that we want you to spend this money, state of North Carolina, state of Colorado, state of whatever. But there is discretion among where you can do that. And our state says the anticipated revenue and proposed expenditures, constitutionally speaking, go through a budget process if that's related to a fiscal year, which these block grants are. That's in.
Mr. Worth, I'd like to go back to the broader implications of your argument and follow up on some of Justice Irvin's and Justice Earle's questions. What is the universe of state money that the legislature is constitutionally not permitted to appropriate?
Well, Your Honor, there's no money for which the General Assembly can't appropriate. No money leaves the state treasury except by appropriation by law. All the money is in the state treasury. I think the question is, are there boundaries on the state of North Carolina and therefore the General Assembly on what they can appropriate that money for? And the answer to that is yes. Simply pushing the money through the budget process does not change the appropriations. The Court of Appeals noted that when they said the only difference in these three block grants, or in an example, one of them, is that money is moved from one category to another category. It has not been argued by the governor in this case that the General Assembly misappropriated the money or that it's beyond the terms of a grant.
Right, but let's move beyond the block grant universe. Didn't we see a few months ago in the Stein lawsuit that the General Assembly recently passed a law changing the way third-party settlement money is to be dealt with by the state? By your argument, that's completely constitutional, right?
Yes, it is. In fact, I believe the Volkswagen settlement proceeds were a portion of this case and were dismissed by the governor when that money has been appropriated, or it was dismissed even before it was appropriated, but it's been appropriated consistent with the governor's plan on how to use that money.
Well, but my point is, if the legislature has the authority to do that, why don't they have the authority to change or repeal the statutes that currently allow donations to the university, to museums, to go directly to the intended recipient?
Well, Your Honor, the state of North Carolina allows the legislative branch to make laws, and it can make the laws that it sees fit. So could it possibly repeal some of this? Conceivably, yes. Could it do away with the city of Charlotte or Wake County? It could. Would it ever be wise to do something like that? No, it would not be, because it would jeopardize the funds that are coming to the state for these specific grants. And I don't think anybody in the state wants to lose money that can be used. But the idea here is, whose authority is it to create and resolve the goals, the priorities that can be used with that money. And in our state, in our Constitution, we say that that is the priority and duty of both the legislative and executive branch. And the governor is arguing that is his responsibility alone, that he wants to exclude the legislative branch, exclude Article 5, Section 3, and use that money that's for the revenue of a specific fiscal period for himself.
And I want to ask,
and I don't believe
Mr. Phillips' argument about custodial funds. Can you talk about what are and are not custodial funds?
Yes, Your Honor. When you look at custodial funds, you can see that custodial funds are those that are have a fiduciary capacity associated with them. And two of the examples given by the controller, Office of the State Controller in the record, are state tax collections held for local governments. And you've also got vehicle property tax held for local governments. So the DMV, as we all know, is collecting state property taxes on those vehicles at the same time you're paying your state registration. That's coming into the state treasury, but those are fiduciary or custodial funds because they are not being collected for the state of North Carolina. They're being collected by the state for Wake County or for Forsyth County. And what we know at that time is where that money is going to go right then and there when it's collected. It's passing through the state treasury. It is being appropriated by law, but it's not the money is collected not for the state. We also have examples of in the statute you can see of pension funds, sort of like the retirement funds, the judicial pension fund. That money is still in the state treasury, but it cannot be appropriated for any other purpose other than that. So the money is all in the state treasury. There are limitations on appropriation set by, for example, the Constitution or other federal law. The purposes, a deed or a grant may do that, but it's all still in the state treasury and appropriated through our process. And I don't believe that the parade of horribles that Mr. Phillips speaks about is going to happen with this particular situation, because Session Law 2017-57 is not where the General Assembly first created the idea was going to appropriate block grants through the budget process. That's A, in our Constitution, but B, has been the state of the law since this Constitution was founded in 1968. So when the Court of Appeals maintains the status quo, I don't find that to be indicative of a massive sea change that's about to happen. And it wasn't a change in the law that created this issue.
What do you make of, I had a discussion with Mr. Phillips about how he would identify which funds were and were not custodial, as he used that word, for purposes of determining who could appropriate the money. And one of the things he pointed out to, and this is certainly an accurate depiction of the language of at least the federal statutes that I've looked at, is that the administration of these funds is vested in a state executive branch agency, and that if there is a misspending of the money, that's the entity to whom the federal government's going to look to address the question. What's your response to that argument?
Your Honor, it's twofold. First of all, the federal government is not, they may send a letter to the Secretary of Department of Commerce, but they are looking to the state of North Carolina if there's an issue. They're not looking to the Secretary in and of himself or the governor in and of himself. They are looking to the state of North Carolina, and the state of North Carolina is on the hook. It's on the responsibility for appropriating those funds, just like the state of Colorado would be, despite internally they have a different process for distributing those funds than we do. The state, as we can see from the congressional record, is not, or the Congress is not necessarily concerned with who is doing that appropriation at the state level. That is up to the states. That's what it said. But if there is a problem, it's going to communicate with the state, and we always communicate with the executive branch. That's the face of the state, not in and of themselves, but as an agent of the state. So I think the federal government would look to the state for that. And Your Honor, as to Mr. Phillips' test, I don't know that he's really articulated a test as to how these federal block grants would happen. The question was, what was unique about this? There's nothing necessarily unique about this, except for the absence of specific legislation from Congress that says that these block grants can be used or can be appropriated by the General Assembly.
If we don't look to the specific terms of the grants, as he suggests, what do you make of the language from in re separation of powers, in which the court in essence said we don't know enough about the various things about these grants in order to make this, render an advisory opinion, and therefore we're not going to. What is your view of why the court pointed to those particular issues as a reason for not answering the question that was posed to it?
Well, Your Honor, I don't know what was in the record in that case, but as an advisory opinion, I'm assuming it was light, and it was simply a question to the court of what they believed to be the case.
Well, and I think that's fairly clear. They said they didn't have enough information to make the determination that they were asked to with respect to block grants. Why would that make any difference?
Well, at least in the question there, Your Honor, I think they were looking at whether the money could be moved around. And there would be a question about looking at the specific purposes of a grant or a donation of something like that to see if the money could be moved from one category to another. Here, we don't have an issue with the priorities set, the guardrails set by the General Assembly on the governor's discretion. And I think that if the court had known that at the time, having had in the record the federal law that we have, they could see that there is no federal law that would restrict this money coming through the appropriation process. But I think what's intriguing about some of the emphasis that the court put on it was that particular statute said the money would be received by the General Assembly. And the court highlighted that and said, we're not so sure that's right. And I think what the court means by that emphasis is it's more likely that the state of North Carolina is the recipient of funds and not a specific agency or branch of government. And that is correct. That's what we see in Article 3, Section 5, and why you can appropriate through the budget process these receipts of public money of federal funds.
I'm sorry, Justice Earl.
No, please go ahead, Justice Morgan.
Thank you. I'll keep it brief. When I heard you say a few minutes ago that if there was a concern that federal government may have with an allocation, that the executive office would be the face of the state's response, do I understand you to agree with the governor's position then that the governor's office would be the accountable entity for such an inquiry?
No, they're not. They're not financially accountable for that. It's still part of the state budget process. If the state of North Carolina misappropriates the money, the state is going to be on the hook for that. That's why we see, even if you sue the office of the governor, you're suing the office of the governor in their official capacity. You are suing the state of North Carolina.
But in terms of an accountability aspect as to defending why the allocation was made the way that it was, you're saying that the governor's office is not accountable in that sense?
They're accountable in the sense of responding to the inquiry, yes. And my guess is that they would note that the money was specifically moved from one category to another. Even the example that Mr. Phillips raises that's particular in the record about the community block grant was not an issue of concern for the federal government, only in so much as they said, hey, it looks like you're using the money for a different part of the plan. Do you want to update your plan? That's all. You want to update your plan to show that you're spending the money in this category instead of that category over there. That's all that was issued at that point, Your Honor. But yes, I think the executive branch would take the lead on that because that is the role of the administering the laws as enacted by the General Assembly. Your Honor's point. I'm sorry, Justice Earls, you had a question as well.
Well, somewhat along the same lines, what significance do you place on the fact that when the federal government is making this block grant to the state, that the process for the state receiving those funds is a drawdown process, not simply, it's not that like at the beginning of the year, they transfer all the money to the state treasury. The state actually has to indicate what it's spending the money for before it comes in. So why isn't that much more targeted and directed like a custodial function?
Well, Your Honor, I don't think that particular process, the drawdown, that's certainly unique to how the money goes to its third-party recipient. But all of budgeting, the entire budget process is really a prospective budgeting process. It is both as the Constitution notes, it is the anticipated revenue and proposed expenditures. So if the anticipated revenue falls, like we might have a situation now, that's going to adjust the budget and what we can spend the money on. So the fact that the money is in the state treasury for a nanosecond versus 6 years is no different to whether it needs to be appropriated by law, and that appropriation occurs through our budgetary process, both under the State Budget Act, consistent with our Constitution. And Your Honor, I see that my time is almost concluded or almost done. If I can, I would like to look at, based on the tests that the governor has not really articulated very well, you look at in Colorado, and the court in Colorado in a dissent where they've been embroiled in litigation for years since their decision says, while this court may not themselves distribute federal funds given to the state, they will henceforth on a case-by-case basis decide whether the executive or the legislative branch will be entitled to that privilege. We are very fortunate in North Carolina that we don't have to make that particular call all the time, because as the Court of Appeals unanimously rejected the governor's theory that these block grants exist separate and apart from that well-worn budget process, that constitutional process that we have, and determined that the method of distributing these grants for the last 40 years is not unconstitutional. This court should affirm. Thank you, Your Honors.
Thank you, Mr. Wharf. Mr. Phillips, rebuttal.
Thank you, Madam Chief Justice. The first thing I'd like to do is focus the court on those cases that Mr. Wharf just spoke of. Justice Ervin, you asked about a standard. In Lamb, the Colorado Supreme Court addressed these three specific block grants. They were among those that were before the court for consideration. The court said that it would look to the purpose the state is directed to accomplish, the manner in which the purposes are to be accomplished, and the restrictions placed on the funds. In Massachusetts, the court employed the analysis almost exactly that we urge here. First, they determined these funds to be custodial funds, and then said that for the General Assembly to appropriate them would result in the legislature's interfering with the right and the obligation of the executive to decide the extent and manner of expending funds and performing its constitutional duty faithfully to execute and administer the laws. I also want to point out the distinguishing facts in the New York and the Pennsylvania cases, which are discussed by both parties. Those in New York and Pennsylvania, both states' decisions were driven by appropriations clauses very different than ours. In New York, the determining vote was based on the fact that its appropriations clause not only governed funds in the state treasury, but also any of the funds under the treasurer's management. And in in Pennsylvania, the appropriations clause articulated within it an exception for funds that were not in the state treasury, which our constitutional appropriations clause does not do. And the court there said, given the fact that our Constitution articulates the exception, that must be it. Next, I'd like to turn to a point that Mr. Wharf he referenced several times the letter from HUD to the state on February 3rd, 2017. This is in the Rule 9 appendix at page 380. I think it's important to note what that letter says. This letter is a follow-up to our meeting on December 20, 2016, where we discussed how the current use of CDBG funds does not appear to address the high priority needs identified in the state's most recent consolidated plan. As we've discussed, it's the executive branch that submits a plan for how these funds are to be used. And as we see here, the federal government holds the state to its plan. The general is there are a variety of ways that funds, CDBG funds, for instance, might be spent on moderate to low income housing, on water projects. The state puts in a plan that says, here's how we're going to use them. And when the General Assembly goes to appropriate those funds, it might be consistent with the federal statute, but inconsistent with the plan. And it's the executive branch that holds, and it is the executive branch that the federal government holds responsible for executing on the plan which the federal government has approved in deciding to allow those funds to be given to and used by the state of North Carolina and the executive branch. Finally, Your Honor, I'd like to note, the General Assembly claims that Article 5, Section 7 says that it would read Article 5, Section 7 as appropriations made by the General Assembly. But when you look at that clause in the context of the rest of Article 5 and Article 9, Section 6, that's wrong. Your Honor, for the reasons we've set forth, we'd ask that this court reverse the Court of Appeals and declare that the General Assembly's appropriations of these 3 federal block grants violates the separation of powers. Thank you.
Thank you, Mr. Phillips and Mr. Wharf, and to all counsel. Madam Clerk, would you recess us? Madam Clerk?
Yes, Your Honor, I'm sorry. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.
Thank you all.
Thank you.